Good morning, sir.
Good morning. Tim Brown for Mr. Daniel, if it may please the Court. This is a very fact-specific case, and at the heart of the disagreement around the facts is the driving that the officer observed the night this happened. I think it's important to go through that piece of it, because it really is the basis for which the Commonwealth is going to urge that driving crimes had been committed. There was probable cause to believe that those driving crimes had been committed.
Before you get, let me just ask you this. Quite apart from the details of the driving, did the judge or the officer, well, let's start with the officer. Did the officer testify to a concern, to a thought that maybe he should be arresting the driver for operating under the influence of marijuana? Was there any testimony to that effect?
No. There were two moments. One was an abrupt turn. The officer used the word abrupt, and the motion judge adopted that in her findings, and also an abrupt stop when he activated his lights. And so there were two abrupt pieces of driving.
I take it he, the officer, may have said something about, with respect to the abrupt stop, that he had to do an abrupt stop as well, or something like that.
That's right. He said that the stop was abrupt enough so that it almost caused him to rear-end the vehicle.
But did he say anything about worrying about her ability to drive? I mean, because she was under the influence.
I believe not. That wasn't argued, nor were any findings about that made.
Or any testimony. That's my question. Was there any testimony?
There was no testimony about that. There was a description of the driving. In addition to...
But there was also no testimony that any sobriety test was done.
That's right.
And there was no reference to anything about the eyes or the conduct of the individual that would suggest that there was any suggestion that the person was under the influence.
No. The cases that the Commonwealth cites for operating under the influence, in this case, those cases all involve alcohol, do involve physical manifestations, glassy eyes. Here there were no outward manifestations testified about, nor any behaviors.
Did she, I can't remember, did she drive the car after your client was arrested?
They were both arrested.
Oh, they both were, okay.
But she did drive the car again at the officer's
Oh, no, I understand up to
request.
the curb. Yeah, but, I mean, she didn't drive away. I forgot that.
But at the time he requested her to continue to operate the car, there didn't seem to be any concern.
So are you suggesting that there was no probable cause to make an arrest for driving under the influence of marijuana?
Yes.
And you're suggesting that because he didn't do sobriety tests?
No. I think, were there evidence in the, that certainly would be a good fact. If she had been administered and failed driving tests, that would certainly make probable cause. Were there facts in the record about any kind of outward manifestation of impairment, either in her
dangerous driving combined with marijuana coming out of the car, and possession of marijuana on her person? I mean, that's not probable cause?
Certainly not possession of unburnt marijuana.
That's one factor. She had marijuana. She claimed she hadn't been smoking it, but there was smoke in the car, and she engaged at 3:40 in the morning, driving without a headlight and making a left-hand turn without a signal. I mean,
there's no question. There were some civil violations here.
I'm not talking about civil violations. I'm saying this is probable cause to believe the person was under the influence of marijuana and affected her driving. You don't have to do a sobriety test to reach probable cause determination, do you?
No, I don't think you do, but I think you do have to have dangerous driving, and that's why I think the facts around this are so important. When Officer DeLeo first saw the defendant car with Ms. Taeto driving, it was coming toward him, and he immediately noticed that there was a headlight out. And then, without signaling, another civil violation, she...
Made an abrupt turn to the left.
Abrupt.
Left.
Now, but what you don't have, it's to his right, to her left, in front of his car.
Right.
Importantly, it was 75 feet in front of his car. It wasn't, there's no...
I don't see how that's so persuasive.
Well, it doesn't... What it means is that there was no...
She didn't hit him. She didn't come close to hitting him, but she made an abrupt turn.
Didn't come close to hitting him, didn't
No
come
signal.
close to hitting any parked vehicle, no screeching of the tires. It was, the word is abrupt. And I think the Commonwealth will urge a real divergence from the law as it is now in terms of negligent operation or driving under the influence. If this is,
let's say he pulled her over and in her lap is a can of beer, right? No probable cause to believe she might be driving under the influence of alcohol. Smells alcohol coming from the car, and there's an open can of beer, let's say, between her and the passenger.
in between,
Yeah.
I think in that case you'd need a little more to show that she was consuming and under the influence.
Even for probable cause.
Yes, probable cause is
Alcohol on her breath?
you're getting a lot closer.
All right.
Yeah.
So smoke-
If there was, I think the presence of smoke does not give rise to a presumption that everybody present is smoking.
Well, the problem with smoke, I guess, in marijuana is you don't have to drink it to be under the influence of it. You can be in its, presumably, people smoking in a car, everybody's breathing, right?
I don't think there's any authority to say that secondhand marijuana smoke is impairing of a driver.
Okay.
What's the authority about impairment and what that means with respect to driving and being under the influence, a fairly broad term, of marijuana as compared to, for example, lots of evidence regarding impairment and the level of impairment, in fact, to the level that we have it in the statute, so that we can conclude with some basis that that means you can't be driving. Is there anything?
Well, the statute is, as you suggest, a little less specific about drugs than it is about alcohol. With alcohol, it talks about specific blood alcohol or levels that would register on a breath test. With drugs, it simply says under the influence of drugs. And the problem with the probable cause analysis here is that there just isn't evidence that she was under the influence of drugs, apart from the smell. If the smell of marijuana gives rise to a presumption that everyone present is smoking and is under the influence of marijuana, that too is a departure from the law as we have it. The facts here really are not very dissimilar to Cruz in that regard. The defendants in Cruz make a similar sort of denial, well, we were smoking earlier in the day. And that wasn't enough to consider them under the influence. Here, there's the same sort of a denial, but
So the officer was not empowered to look for the joint, so to speak. Smoke coming out of the car, no, we haven't been smoking. No, here, I got some marijuana on my person. The officer's not empowered to say, well, step out of the car, let me take a peek under the seat to see if you've got a joint down there.
well, I think that's also Cruz. I think there isn't. You need probable cause
Even though
to
there's
believe.
operation here, clearly operation here. Cruz,
I
there was
think you
no
need
clear
impaired-
evidence of operation. It was just parked car.
Well, there's someone in the driver's seat. I think that
Parked car.
in the driver's seat of a parked car, which
Yep. And then we made very specific point of that. Parked car, no evidence of its operation.
well, I think you need evidence of operation under the influence, not simply
So on our
operation.
facts, so you would say then this case will be resolved by the facts. If there is not negligent operation or erratic driving, the police shouldn't have made the stop. That's,
No, no,
You
no.
The
say
stop is valid.
Okay.
The stop is
So-
valid for sure.
But then, once they make the stop and they detect the smell of marijuana, they can't go beyond that without the negligent behavior. That's your position.
Yes.
Well, you don't, I mean, the fact is here, the officer didn't say he was at all concerned about that,
Right.
right? I mean, so it's not just, it would be a different case if the officer had said he was concerned about whether she was under the influence. It
Yes.
seems to me it would be a different case.
Certainly. And it may be, without any the nature of this driving, an abrupt stop, I don't see how legitimately you can say that an abrupt stop in response to the flashing blue
He
lights.
weren't at the scene. I mean, I'm not willing to go that far, but
Well,
somebody might.
the level, I think you need something more than the smell. And here you don't have that. You have operation, certainly, and you have perhaps a presumption.
Have smoke coming out of the car?
Yes, there's I think, I'm not saying there isn't a presumption that somebody in the
Car was
car,
smoking.
but I don't think there's any evidence about which one, certainly not that both people in the car were smoking marijuana.
Would it have been unreasonable for the officer to say, with smoke in the car, it's reasonable to infer that they were all smoking?
No.
Would that be wrong?
Yes.
For probable cause purposes. For probable cause purposes.
I think so. You need some evidence you need probable to believe that.
Three people in a car, and the officer flashes his light in there, 3 people in the back seat, and there is a bag of cocaine or something that the officer sees. He can't arrest all 3 of them based on probable cause?
Well, I
May
think,
not be for sure whose it is, or...
But you're talking about a behavior. I mean, possession, anybody within arm's reach, at least at that level, can be reasonably thought to be possessing the cocaine. But here you're talking about something else.
Can I be arrested if I'm driving in an impaired fashion and I've taken a prescription, appropriate amount of prescription codeine, for example, right? I mean, that's subject to the statute, correct?
I suppose it would be.
Okay, so I'm driving and I make an illegal left, or I don't put my light on, right, to make a left turn. And I've got passengers. And I've taken this a while ago, and I put my codeine prescription bottle in the center of the console, and I've got a bunch of people sitting around. Would that be, if I were impaired, even if I were, let's say I were a little woozy looking, how far would that go? Maybe
Well,
to me.
it depends on if the wooziness and the physical manifestations thereof got to probable cause to believe that a crime had been committed, then I do think the automobile exception gets you a search for that codeine bottle. Do your
But
facts
without that, probably not.
I agree.
So hypothetically, let's say someone ingests medical marijuana. We've voted for that here in Massachusetts. They're under the influence and they drive erratically. Police make the stop. They smell the odor of marijuana. They can search, right?
I think you're getting there, yes. I think probably to lock down probable cause, field sobriety tests would be probably the best route to it, but you're very close on those facts. But here there isn't erratic driving. Erratic is a word that the Commonwealth uses, that the appeals court used, but which the motion judge nor the officer used. Just wasn't an issue at the, I'm sorry, Your Honor.
No, I finished. I want to just turn to the question about the officer testified, and the motion judge, I guess, didn't credit, but the officer testified that he was afraid for his safety. I'm talking about, yeah. And
Thank you for getting to that.
and the appeals court said, well, yes, she did say that, but in the circumstances, it's an objective test. And so I would like you to address that.
Well, as to whether it's an objective or a subjective test, since I only have a minute, I'd like to leave that rest on my brief on the legal issue. But factually, here you have the motion judge also found not only that he wasn't credible about safety concerns, she also found that these were not furtive movements. The Torres case, which I cite in my brief, says that fidgeting and nervousness is not enough. I think this is much closer to fidgeting. This is not the kind of movements that you see in the cases where a heightened awareness of danger is found. You almost always have reaching down out of sight for long periods of time and other factors. The car didn't stop right away. These are known people to be dangerous. Here, all you have is some moving around. He never goes out of sight. He never reaches to the glove box, importantly. He's in the vicinity of the glove box, as any passenger would be, but he never reaches. The officer describes him looking down at his lap, and his arms are moving some. This would be a real departure. There has to be some daylight between Article 14 and the Fourth Amendment, and this really closes it.
Thank you, counsel.
Thank you very much.
Good morning, Your Honors. May it please the Court, Zachary Hillman on behalf of the Commonwealth.
Mr. Hillman, let me start here. This would be, I think, a fairly easy case, at least in my mind, if the question of whether the driver had been operating under the influence was raised in the trial court. It wasn't raised at all. I mean, and nor in the appeals court, as best I can understand. So how are we to assess this?
It was actually raised in the district court, Your Honor.
Okay.
At the end of the motion to suppress hearing, the parties asked for time to file a memorandum. Commonwealth and the defense counsel both did that. The Commonwealth's memorandum is included in the Commonwealth's appendix, and at page 52 it raises probable cause to arrest based on OUI. So it was in front of the motion judge. She didn't address the issue in her findings and rulings. This is a case where I think had she would have had to come out on the side of this was probable cause to arrest for OUI. This isn't a case where we just have
Did
this.
the officer say anything about that?
He did not, Your Honor, but he doesn't have to. It's an objective standard. And the facts that he testified to and the facts that the judge found established that the officer had reasonable officer and officer DeLeo's shoes could have arrested this particular individual for operating under the influence. We don't just have the smell of burnt marijuana.
What else do we have?
We have the smell. We have erratic driving.
Well, when you say erratic, what do you mean?
I mean this, Your Honor. It's 20
Which facts do you look to support that
Yes, Your Honor.
conclusion?
It's 20 of 4 in the morning. The officer who's in a fully marked cruiser sees the defendant driving down the street towards him, and she makes an abrupt left-hand turn onto East Street without signaling. He then follows her. When he turns and activates his lights, she comes to an abrupt stop, not over to the side, but in the middle of the street.
Well, let me stop you there. Over to the side, as I understand it, would have been on a sidewalk.
I don't think that's respectfully, I don't think that's accurate, Your Honor. What that means is she could have pulled over to the sidewalk. She did not. That's what she did later on when the officer asks her to pull over. Instead, when he first activates the lights, she comes to an abrupt stop right in the middle of the street so that nobody else can get around her.
The judge found that she came to an abrupt stop in the middle of the left travel lane. Is that right?
That's right, Your Honor. This is a one-way street, and the officer testified, believe it's at pages 23 to 24 of the transcript hearing, that this was a street where if she had pulled over, not even just to the curb, but over to the right-hand side, people could have moved around her. That's not what she did.
Was this a one-lane highway?
It was yes, I believe that's the testimony. It was a one-way street.
One lane.
Oh, one lane. I'm sorry, Your Honor. Yes, I believe that is the testimony. I believe that's a fair inference from the testimony. But
So when we talk about her moving over to the left, if it's one lane, how do you move over to the left?
The officer describes it as one lane, but one lane in which cars could have moved around her had she moved over to the far enough to the right side of the street, which she didn't do. She stops in the middle of the street so that nobody can get around her, which I would suggest is indicative of her impairment. Now,
Well,
Yeah, I mean,
did she? Go ahead.
You know, I mean, generally the police are thrilled when the
Yeah.
balloon lights come on and the person immediately comes to a stop. We're supposed to not do that. We're supposed to drive on and then wait until we can come to an area where we can park over to the side. I mean, it does seem as if the person had not promptly stopped, you'd be before us to say the blue lights went on, the person did not come to a prompt stop and then drove along, even though it's 20 or 4 in the morning and it was quite clear that we wanted them to stop. How can you have it both ways?
I'm not asking the court to have it both ways. I'm merely suggesting that when the blue lights are activated, and the officer testified to this, under the law, she's required to pull over so that people can safely travel by. This was included in the officer's testimony. And there were spots for her to pull over because she does so when he asks her to pull over, when he notices that traffic is starting to back up behind them. So I'm not asking the court to have it both ways.
But he says pull over and onto the sidewalk.
That's not the way I interpret the testimony. I believe it's over to the sidewalk. I could be mistaken.
No, on the transcript of pages 23 to 24, it's if single lane side street, I guess, in the city where there's room pretty much for one vehicle to operate on the travel lane, if one could pull over a little bit onto the sidewalk.
I stand corrected, Your Honor. But he does testify later on that she does that, and that's what he expected, and that's what the law requires.
But generally, we don't want drivers to be stopping and then driving onto the sidewalk. That would probably be seen as a sign of erratic driving if that were to be done.
He was merely pointing out the fact that this particular defendant could have operated her car to a position that would have been consistent with safe driving and pulling over in response to an officer activating his lights. She didn't do that. She stopped, again, it's an abrupt stop, it's not a slow stop. He testifies there's merely feet between his car and her car when they stop. And he can reasonably, an officer in his shoes could reasonably determine that this is erratic driving because she is under the influence of marijuana. And
but yet he does no sobriety check.
That's true, Your Honor.
I mean, is that consistent with what a police officer would do if the police officer truly had concerns about someone's sobriety?
Certainly a police officer, maybe a different police officer would have or could have done a sobriety test. That this officer didn't in this case isn't fatal to the probable cause determination. Again, it's an objective standard, and we're looking at the underlying facts.
But other than these instances of traffic irregularities, is there any observation that the officer makes about her, that she is acting, as she speaks with him in a way that's consistent with being high, as police officers will often do, even if field sobriety testing is not done with regard to alcohol, that the glassy eyes, the odor of alcohol. I mean, someone who has been smoking marijuana may have behavioral manifestations of that, which a police officer could note if they were concerned about the person operating under the influence of marijuana. No such observations were made by this police officer, am I right?
That's right, Your Honor. Apart from the fact that she denied smoking marijuana at all, which I would suggest is evident of consciousness of guilt.
It could be that her passenger was smoking.
That's absolutely true, but he's not required to discount the fact that she's driving erratically. There's a moderate to strong smell of freshly burnt marijuana coming out of the car, and at the probable cause stage, he's not required to discount all other possibilities.
Do we know whether the field sobriety tests that are used to determine whether somebody is under the influence of alcohol apply equally to somebody who's under the influence of marijuana?
There's nothing in the record on that, Your Honor. I did submit a 16L letter on a case. It's the Mandel case out of the appeals court, in which the appeals court noted that there's no way to determine whether a defendant is presumptively not impaired. So I did submit that case to this court.
What do you mean, if they're smoking marijuana?
Yes, Your Honor, as distinct from alcohol. The court noted in that case that there's no test that they were aware of that could determine whether a person is presumptively not under the influence of marijuana. And I guess I would suggest what is the contrary here, that this officer allows this person to drive on impaired by marijuana in a 1,000, 2,000-pound vehicle on the public streets of Boston. I think the alternative is something that this court should not sanction, should not say is okay.
I'm sorry, so I lost that point. I mean, are you suggesting that this police officer made this stop or made the arrest because there was concern that the person was driving under the influence, even though that's not what the person was cited for?
No, I'm not suggesting that.
Yeah,
I'm not suggesting that.
There's no dispute that that the police have an obligation to stop and arrest people who are driving while impaired. The issue is whether the inference here was sufficiently strong to permit that.
That's right, Your Honor. I'm merely suggesting that on these facts, it was reasonable. It would have been reasonable for an officer in Officer DeLeo's shoes to have probable cause to believe that defendant Tayeto was operating her car under the influence of marijuana at 20:04 in the morning. Given the erratic driving, given the fact that she testified they had come from, that she said they had come from a party, given the moderate to strong smell of fresh marijuana coming from the car, given her production, burnt marijuana, given her production of unburned marijuana, 2 bags of unburned marijuana.
How big were those bags?
I
take
can't
it
answer that.
They were
I can't
small
answer that, Your Honor.
Because she wasn't
If
arrested.
it was more than an ounce, she would have been arrested, though.
That's right,
for
Your Honor. I think
possession.
that's a fair inference. I think that's a fair inference.
Was there smoke, marijuana smoke, coming from the car?
There was. Well, let me take that back. It was the officer's testimony was it was fresh, moderate to strong smell of burnt marijuana coming from the car.
But he didn't, but there was no testimony that he witnessed smoke, was there?
No, there was no such testimony. I don't think that's determinative. I think the fact that it was
Yeah, but it's sort of been bandied about, but that's not.
that's right, Your Honor. Yes, just for
That
clarification.
reminded me of how early in the morning this was. And so doesn't that also lend some credence to the opposite presumption that to stop on a one-way, one-lane road at 3:40 in the morning when there doesn't appear to be any place to park except on the sidewalk is a reasonable thing to do when it's, what did you say, 24 in the morning? How many people are going to be driving?
Evidently, there were people driving.
But reasonably.
I think reasonably, right.
Would you think there'd be a lot of traffic following it behind you, so you'd have to find a way to get on the sidewalk to let people go by a one-lane road?
I think reasonably, yes. Under the law, you're required to pull over in a safe
Unfit.
manner so that the officer can affect the traffic stop.
Well, what is the law of the road? Is it to pull over to the right or pull over to the left? Does it matter? What if she had pulled over to the left gradually? Would that have mattered?
I think that would have been, I think in this circumstance, it would have been okay because the officer testified that on the left-hand side of the street, there was no cars. So I think that she could have done that. That would have been a lot safer than abruptly stopping the car in the middle of the street so that nobody could get by.
Was there any evidence that there was a left side? I thought it was a one-lane road and they had to go to
On the left side of the street, it's a one-way street. On the left-hand side of the street, there was no parking. It was a residential neighborhood. There was parking on the right-hand side, no parking on the left-hand side.
How do we know she just...
Let me go back to my first question. You say
Yes, Your Honor.
that at some point in a memorandum filed post-hearing, the Commonwealth raised for the first time this question of perhaps there was probable cause to arrest for driving under the influence?
That's correct, Your Honor.
Okay. And but that was not developed as a factual matter at the hearing?
I mean, I would disagree with that. Certainly, there could have been more testimony elicited on that point.
Was there anything, did you form an opinion, officer, as to whether or not she might be driving under the influence of marijuana? Anything like that?
Certainly, there could have been.
There wasn't.
There was not.
Okay.
But based
Glassy
on
eyes, did you look at her eyes? What was her speech like? None of that.
That's correct, Your Honor.
Okay.
However, given the facts as developed at the hearing, those facts viewed objectively would have supported the officers.
Now, remind me, was this argument made before the appeals court?
It was not, well, it was, it happened to the appeals court procedurally in somewhat of an unusual fashion because at the time that we filed our brief, Commonwealth versus Cruz had not come out. In between Cruz and oral argument, the defendant filed his brief and the other defendant didn't file a brief. Our office was waiting to receive the second brief in order to ask the court to address, the appeals court to address the impact of Cruz on this particular case. That didn't happen. The appeals court merely scheduled the case for argument, and we argued at oral argument the OUI and negligent operation issues to the appeals court.
Can I ask you, though?
Yes, Your Honor.
Those issues relate solely to getting the driver to exit the vehicle. They don't really have anything to do with the OUI aspect of it. Has nothing to do, it seems to me, at least not obviously so, with the defendant here, who was the passenger.
Right. Yeah, yes, Your Honor. So once the officers have probable cause to arrest for OUI, they also have the authority to search the defendant and the car incident to her arrest for evidence of the crime. I would suggest it was very reasonable to assume that evidence of the crime, the OUI, might be contained in the glove box, given Daniel's movements as the officer approached the car. the leaning over, the fumbling, the rocking of the shoulders as if he was fumbling with something, it would have been reasonable for the officer to assume or believe that evidence of the crime of OUI would have been contained in the glove box. For practical purposes, it would have been reasonable for the officer to ask Daniel to exit the passenger seat so that he could effect a search of that glove box.
Did he also effect a search of Daniel?
Well, I'm
That's justified on other grounds, I take it.
on other grounds, certainly, Your Honor, on other grounds, on reasonable, on officer safety grounds, certainly.
Even though the judge said no?
Well, the judge did not credit the officer's statement that he had a heightened awareness. She credited all of the factual assertions that the officer made. Given those factual assertions, a reasonable, and we're looking at an objective standard, what would a reasonable officer in this particular officer's shoes, what would he have
She
felt?
had other reasons for not crediting it. For example, letting them drive to park the car, leaving them to go back to his car and then to deal with the traffic. I mean, it wasn't just that she just sort of baldly said, I don't credit it.
Your Honor, I see my time is up. May I just answer this question? And I think all of those facts go to whether this particular officer feared for his safety. It doesn't go to whether a regular officer in this particular officer's shoes would have feared for his safety, given the underlying facts of the incident. Given those facts, particularly the rocking of the shoulders, which I would say is right on point with the actions in Stampley, Officer DeLeo reasonably feared for his safety.
Thank you, counsel.
Thank you, Your Honors.